Okay, well, welcome everyone to another webinar in the series of webinars produced by the Guildhall Chambers PI and ClinNeg teams. Today, the subject that we will be looking at is liability in road rage cases. I hope that all of you that signed up to the webinar today will have received a set of notes which comprises no more than a list of the relevant cases in this area set out in chronological order. Most of the cases have links, so that you should just be able to link through to Westlaw or the other resources if you want to see the judgments in detail. As always, the slides for this webinar and indeed a video of it will be available after today for anyone else who you know of that might have an interest in this area but wasn't able to participate. In a slight change to the way we normally run things, I'm not going to invite questions on the PowerPoint chat. Usually we don't have any questions, and there's a sort of pregnant pause at the end of proceedings whilst we work out that that is the case. However, on my notes is my email address, so if in the course of this presentation anything arises that you'd like to discuss in further detail, perhaps you can send me an email and I can assist you after the event. Okay, so if I can move my slide forward. Yeah, I'm going to start with some statistics. There are a reasonably high number of road rage cases reported in the UK. My hunch is that the figures are high enough to mean that probably quite a few of the people watching this seminar have been involved in one way or the other in a road rage experience. As I say, the statistics are quite high. 3,500 cases reported in 2019, but those statistics are only compiled by. I was talking about statistics for road rage cases. They are reasonably high, and I was saying, I think at the point I was cut off, that there were 3,500 cases in 2019. That represents about 50% of the actual number. And those are the numbers, of course, reported to the police. I suspect a good deal of these sorts of issues are not reported to the police. You'll see some other statistics set out there. Nothing particularly sophisticated, just what's available on the internet. What I found quite surprising when I had to run a road rage case myself fairly recently is that despite these relatively high numbers, there isn't a reported case that I could find at any rate on Westlaw of what I would term a genuine road rage case, one where a driver gets out of his car and assaults another driver. And that wasn't helpful for me because I was litigating a case of that type and I was obviously hoping to find a useful example. I wasn't able to do so. But in the course of preparing for that case, I obviously needed to go through the available cases and work out where my client stood in terms of liability. And really that is the driver for this presentation. So I'm going to start by looking at routes to liability in that type of scenario. The first and the most obvious one is that the typical road rage assault will be just that. It will give rise to the tort of battery, and assuming that the assailant has assets, then there can be a simple action in tort to recover damages for the assault. The problem is, of course, that there's probably quite a high correlation between the sort of person who commits a road rage assault and the sort of person who has no assets. And so in many cases, that avenue simply isn't one that provides a practical solution. So we have to look at other routes. Next in the list would be an assault of that type where the perpetrator of the assault is at work when the assault happens. Some of you will be familiar with the decision of the Supreme Court in Mohammed and W.N. Morrison supermarkets. That was a case involving a chap working in a petrol station, I think, Somalian man turned up and asked a question about something. One thing led to another, and the Somalian man was then assaulted by the petrol station attendant. Vicarious liability for those sorts of assaults is not the subject matter of this talk, but if you have a case where an assault is carried out and the assailant was at work, Mohammed is the case that you need to go to. And just to remind you that the key element of the test is to look at the position in which the assailant was employed and whether there was sufficient connection between that position and the wrongful conduct perpetrated. And some of you may be aware that in the Mohammed case, the Supreme Court found in favour of the claimant in that case. So again, if the assailant is at work, you may have a route through to an employer who will have assets or an insurance policy, and that sort of case, relatively straightforward. If those avenues are not open to you, and subject to the fourth point on this slide, we have, of course, the Criminal Injuries Compensation Authority. That is, if you like, the statutory scheme set up to compensate victims of crime, but the awards are modest. There is, I think, a £500,000 cap. That's the maximum that can be awarded under the scheme. The personal injury tariff awards are relatively low, in my opinion. Loss of earnings is measured not by the actual loss of earnings, but by the going rate for statutory sick pay. Most of the benefits that one is entitled to in this situation are all offset. So you're not going to make anything like the type of recovery that you would make in a straightforward civil tort action. And so that leads us on to the fourth point on this slide, the question of whether a victim of a road rage assault can make a claim against the road traffic insurer, or if there's no insurance in place, the MIB in this situation. So let's look at, again, the routes available in a Road Traffic Act type of scenario. Well, the first port of call is the policy of the insurance of the assailant. Most of the time, almost always, I'm going to suggest, this won't yield a result. That's because almost all policies of road traffic insurance in this country are drafted so as to exclude deliberate acts. And whilst the law has been in flux somewhat over the last decade or so, the position now is that if the policy itself excludes deliberate acts, which obviously would include an assault, then there will be no liability under the Road Traffic Act section 151 for the insurer to satisfy a judgment either. That flows from the Bristol Alliance case that you can see on the slide there. It was a battle between insurance companies, if you like. The facts were that a chap called James Williams was very unwell. He was suicidal, drove his car down the M32 in Bristol at very high speed, I think 100 miles per hour, crashed into a low wall, car flipped over a couple of times and ended up going through a plate glass window in the House of Fraser store, which some of you may be aware is at the end of the M32. And the property insurers for the House of Fraser and the road traffic insurers for Mr. Williams got into a tussle as to whether they, that being the road traffic insurers, had to satisfy the payout made by the property insurers. Anyway, the property insurers lost. Section 151 did not bite. Of course, that left the MIB provisions in place, but the MIB provisions don't pay out for subrogated claims. And so the property insurers lost that case. So, as I say, in most cases of assault, what you'll find is that the assailant may have insurance, but the insurance won't help because deliberate acts are excluded. What that leaves you with effectively is one further avenue, although I've split it down into points 3 and 4 on the bottom of this slide. The avenue essentially is the MIB, but many of you will be aware that in a case where there is some insurance in place for a vehicle, even if that insurance didn't cover the use of the vehicle or the driver and so on, then under Article 75 of the Articles of Association of the MIB, any concerned insurer in that respect has to satisfy the claim. But all they're satisfying isn't the judgment per se, it's satisfying the liability that the MIB would have to pay out under the MIB rules. So there is the relevant article of association that provides that an insurer with the Road Traffic Act liability has to, but that means a liability whether arising out of negligence, breach of statutory duty or otherwise, arising out of the use of a motor vehicle on a road or other public place, as is required to be covered by a policy of insurance or security under the Road Traffic Act 1988. Well, what does that mean? What that means is the liability set out in section 145 of the 1988 Act. Section 1453, right at the bottom of the slide, death or bodily injury to any person or damage to property caused by or arising out of the use of a vehicle on a road or other public place in Great Britain. And it's those words that I've highlighted in yellow that really form the focus of the talk today, and those words are the subject matter of the cases that I will be going through in due course. Because the question is, in any type of road rage assault, whether you can get the assault within the meaning of those words or not. And of course, the facts of assaults vary. Some assaults involve direct use of the vehicle to ram into somebody. Other assaults involve leave the vehicle well behind, and someone might run quite some distance or might commit the assault sometime later. So that's what we're going to be looking at. But before I do so, I'm just going to mention, just by way of clarification, the case of Gardner and Moore. What that provides is that even though deliberate acts might fall through the Road Traffic Act and not catch an insurer, they will nonetheless have to be covered by the MIB. Gardner and Moore was a case where the assailant drove his car into collision deliberately, causing an injury to the claimant, and is one of the sort of easy road rage cases, I suppose, and it is an example of a road rage case, but it's one involving direct use of the vehicle. That is not a difficult case, as you will come to see. So, before I start galloping through these cases, which I will do in chronological order, I just want to set the scene, if you like. The law isn't particularly complicated. The words we're looking at, caused by, arising out of the use of, are not particularly difficult, let's face it. But lawyers being lawyers, the cases are, some cases go one way, some cases go another way. But the touchstone I'm going to suggest is that you must never let any case that you're dealing with, don't get too far away from the facts. It's very easy to get buried in the cases that I'll go on to discuss. But the most important thing is obviously to keep in mind the facts of your case and whether they fit within those words. The situation is, I suppose, complicated legally somewhat, because the cases are a mixture of cases in the UK, but also cases from other Commonwealth jurisdictions, principally Canada and Australia. They have similarly, although not identically, worded road traffic statutes, and so some of those decisions will be germane to the issues. But of those, particularly the Canadian ones, they might appear helpful to an insurer in a road rage case, but they've got to be seen in context. So let me start off with the first case. This is an Australian case, and it was a case involving a workman who was injured in the course of his work when he and a number of his colleagues were loading a hoist onto the back of a lorry. And as I mentioned earlier, the road traffic statute in Australia is similar to the Road Traffic Act 1988. And the court had to look at the meaning of the words caused by and arising out of. And I've set out there the essential ratio of the case. The expression arising out of must be taken to require a less approximate relationship than the words caused by. The words injury caused by or arising out of the use of the vehicle postulate a causal relationship between the use of the vehicle and the injury. Caused by connotes a direct or approximate relationship of cause and effect. Arising out of extends this to a result that is less immediate, but it still carries a sense of consequence. So you might think a relatively straightforward, if not obvious, explanation of what the words we're looking at mean. So that was in 1965. We jump forward to 1987 and the case of Dickinson, another Australian case. This was a case where the claimant was aged 2. He was sat in the back seat of a car next to his 4-year-old brother. They were being driven somewhere by their father. En route, the father passes a record shop, decides he's going to pull over, pop into the record shop and make a purchase. He does so, and he leaves his 2 young children in the back seat of the car. Whilst he's in the record shop, unfortunately, the 4-year-old finds a box of matches between the front seats of the vehicle, plays with the matches, starts a fire, and the 4-year-old manages to get out of the vehicle. But unfortunately, before he was injured, the car caught fire and burnt the claimant. He wasn't killed, but he was badly injured. And a claim was brought against the Motor Vehicle Insurance Trust on the basis that the 2-year-old's injuries arose out of the use of the vehicle. And so there was some commentary in relation to this. And you'll see from the slide, whether or not the appellant's injuries were actually caused by the use of the motor car, it is sufficient to say that they arose out of such use. The test posited by the words arising out of is wider than that posited by the words caused by, and the former, although it involves some causal or consequential relationship between the use of the vehicle and the injuries, does not require the direct or proximate relationship which would be necessary to conclude that the injuries were caused by the use of the vehicle. So this is the first example, if you like, of injuries. It's not an assault, but injury sustained in a sort of not obvious way, not involving actual driving of the vehicle. So moving forwards, we go across to Canada now, and I have to start by saying you have to take care with the Canadian cases because the wording of the statute is very similar but not identical to that in the UK, and you'll see that I've underlined some words there: ownership, use or operation of the vehicle. That's a sort of slightly different scenario to the one that we're looking at. But this case is important because it features or is considered by later cases. And it was a case where Mr. Amott was returned to his car to discover that some gang members were trying to break into it. He somehow managed to get into the car himself and drive away. But as he did so, he was shot and injured by a member of the gang. And in Canada, there is, if you like, no fault insurance held by the owners or operators of vehicles that will pay out if they themselves are injured as a result of using their car. And this case is germane to the issues we're talking about because it is an assault type case. And you'll see there that a similar-ish test was applied. Is there some nexus or causal relationship, not necessarily a direct or proximate causal relationship, between the appellant's injuries and the ownership, use or operation of his vehicle? Or is the connection between the injuries and the ownership or use of the vehicle merely incidental or fortuitous? And as you'll see as we go into the later cases, that phrase merely incidental it becomes used more widely in terms of cases where the claimant's lost, where they are the victim of an assault. There is a connection to a vehicle, but it would appear that courts are readily prepared to separate acts of violence and assault and the like from use of the vehicle, and they end up saying that the incident was merely incidental. So we come to the first decision of the English courts. It's a relatively well-known case. It is still the leading authority on the question of caused by or arising out of. The facts were that Mrs. Bentley was driving her car. She runs out of fuel but manages to pull over, and she gets out of her car, scratches her head, tries to work out what she's going to do. About 10 minutes goes past, and she then spots a friend on the opposite side of the carriageway. And there was some shouting between Mrs. Bentley and her friend. And at some point, Mrs. Bentley decides she's going to cross over so that she can continue the conversation with her friend. But unfortunately, she carelessly crosses the road and is struck by the car of Mr. Dunthorne. Mrs. Bentley's killed. Mr. Dunthorne is badly injured. And Mr. Dunthorne sues the estate of Mrs. Bentley for the injuries that he sustained. In the case, there were the judge inferred from a set of agreed facts between the parties that in crossing the road, the purpose for Mrs. Bentley crossing the road was to try and gain assistance from her friend in order to continue her journey. And he went on to find that the accident arose out of the use by Mrs. Bentley of her car, so that her insurers had to satisfy the claim of Mr. Dunthorne. And the Australian cases, the cases that I've mentioned so far, were looked at by the court, and to some extent were applied directly, the Australian ones in particular, the R.J. Green case. And you'll see from the slide, the phrase arising out of contemplates a more remote consequence than is embraced by caused by. Arising out of extends this to a result that is less immediate, but it still carries a sense of consequence. It excludes cases of bodily injury in which the use of the vehicle is merely casually concomitant, but not considered to be, in a relevant causal sense, a contributing factor. So, as I say, that remains the leading authority. It has been subject to some criticism. Within the judgment itself, Lord Justice Hutchinson describes the case as being close to the line. But the court emphasised, and this is why I emphasised at the beginning or earlier in the talk, that really the test is straightforward. The difficulty arises from different factual scenarios that one is considering. So we move now to back to Canada, and this is another assault case. It's, I think, the first proper road rage case in the cases that we're looking at. It involved classic scenario in Canada, I suppose, two pickup trucks driving down the road. And it was one of those roads where 4 lanes merged into 2 lanes. And in the course of that merging taking place, Mr. Duval took the view, as he's quoted in the case, as that he had nearly been boxed in by another motorist. And so 13 blocks further down the road, Mr. Duval decides to get out of his car, approach the car in front, lean in through the window and punch the driver, according to the judgment, knocking off his baseball cap. And so Mr. Duval was sued by the person he assaulted. But then Mr. Duval sued his own insurers for an indemnity against the claim made against him, his argument being that his own policy covered incidents caused by or arising out of the use of his vehicle. And so, if you like, he, the assailant, was trying to argue that his road rage assault arose out of the use of his vehicle, such that his insurers should indemnify him against his own tort. Now, the case failed, predictably, on policy grounds, because Mr. Duval was trying to set up his own crime in support of his own cause of action. So it failed for that reason. But this case is important because it is an example of a typical classic road rage type of assault. But the Canadian court held that the assault was merely incidental to the use of the vehicle. So it's a case that's very helpful to insurers who are faced by a road rage type claim, because it's illustrative of the approach, at least of the Canadian courts, as to whether there is a connection between the punch and the driving. But it's a case that has to be seen in context. Mr. Duval was an undeserving claimant. His case failed for other reasons. Some would argue that a road rage assault clearly does arise out of the use of the car, hence the name of road rage. But nonetheless, the Canadian court didn't agree in this case. And so if you're advancing a claim, expect this to be cited against you, not as a proposition of law, but as an example of the approach of a foreign court to a similar scenario. So the next case, we'll come back to England for that. It's not a road rage case, but it's considering the phrase caused by or arising out of. It involved injuries to a chap called Paul Slater, who was, I think, in his 20s or 30s. But he suffered from Down syndrome, and once a week he would travel to a local daycare centre, and the local authority provided a taxi to pick him up and bring him back home again. And on the day of the accident, the taxi pulled up on the opposite side of the road from Mr. Slater's house. Mr. Slater walked down the garden path. The taxi driver, I think through the window of his taxi, said, "Stay there, Paul," because he could see a car was coming. But unfortunately, Mr. Slater, for whatever reason, stepped out into the road and received catastrophic injuries when he was struck by the vehicle. And Mr. Slater's lawyers sued the county council, but they also sued the taxi driver in an attempt to force the road traffic insurers of the taxi driver to satisfy the claim. And consideration was therefore given to whether this accident fell within the phrase caused by or arising out of. And the judgment is, the ratio of the judgment's quite difficult to define, really. A consideration was given to all of the relevant cases, but you'll see from the slide that the essential ratio was simply that to hold otherwise, in other words, to find liability in the case, would be to give an utterly strained meaning to the words caused by or arising out of, outside the purpose of the statute. And it's clear in that case that there was quite a lot of discussion about the type of risk involved in the case, whether it was genuinely a road traffic accident risk as opposed to a public liability risk. And anyway, the claim failed, and but the rationale given was simply that the language of the act was being, as I say, utterly strained. So that's England. We then go back to Canada, the case of Tench, Erskine and Bowlby. This is another genuine road rage case, so it's a factual example. Once again, we've got pickup trucks and people wearing baseball caps. What happened in this case was that Mr. Bowlby was the passenger in a pickup truck. For whatever reason, he got out of the vehicle and assaulted Mr. Erskine. As a consequence of being punched or assaulted, Mr. Erskine, it would appear, trod on his accelerator and drove into the back of the car containing the claimant, Mr. Tench. And as in Duval, what Mr. Bowlby sought to do was to argue that his own assault arose out of the use of a vehicle, even though he was the passenger in that vehicle. in order to get an indemnification against the claim brought against him for the assault that he committed. It was the same outcome as in Duval. The case of Amos was considered, but the assault was held to be merely incidental. So another chip, if you like, in the pile for the insurers. On a second occasion, Canadian court, road rage attack, but the conclusion was that the road rage attack was merely incidental to the driving. The case is different from Duval, obviously, because Bowlby was just a passenger in the car. So I suppose it would have been harder to achieve victory in that case, but given the decision in Duval, the result was not surprising. Remaining in Canada, we've got Citadel General Assurance Company against Michael Vitalingham. This is one of two further Canadian cases, which I just want to touch upon briefly. The facts in Vitalingham were that some scallywags had taken a vehicle, I think again it was a pickup truck, put rocks in the back of the pickup truck, drove the pickup truck to a bridge over a road or motorway, and then I think just for kicks decided to grab the rocks from the back of the truck and throw them onto cars that were driving underneath the bridge. And poor old Mr. Vitalingham, more than one person in the car was injured, but he was very badly injured. And he brought a claim against the insurers of the assailants involved on the basis that the assault was caused by or arose out of the use by them of their truck. Perhaps unsurprisingly, the claim failed. There's a rather nice line in the judgment: no amount of driving around with rocks gives rise to 1 iota of civil liability. They found that the assault was no more than incidental. And I think it can be said fairly that on the facts of that case, that's not a surprising result. So that's Vitalingham. We've then got Ing Insurance Company of Canada and the Harder estate. This case involved a chap called Grant Harder. He decided that he was going to kill his young son Cole and then commit suicide, and that's in fact what he did. But he put his son in the car, put himself in the car, drove to a remote location, shot his son, and then shot himself. And again, the claim failed on the basis that the assault was no more than incidental to the use of the vehicle. There was a paraphrase of that earlier line in Vitalingham: no amount of buckling coal into a car seat and carrying him to a remote location gives rise to 1 iota of civil liability. But I think it can be fairly said there that the suicide and the shooting of the son probably would have happened anyway through a different mechanism if the truck hadn't been available. The truck really was just, if you like, the background to the assault that took place. So one can readily see that the injuries there weren't caused by or arising out of use of the truck. It was a genuine case where use of the truck was no more than incidental. So that's the end of the Canada cases for the moment. Sorry, that was the Ing case that I was telling you about. So we come back to the UK, and a case which most of you will have heard about. At least you will have heard about central character, John Warboys. Some of you will remember he was a taxi driver in London who committed a number of rapes and sexual assaults within his taxi. What he would do is he would, once he'd finished his sort of legitimate taxi business for the evening, he would drive around the streets of London, and if he alighted upon a single female walking home, he would stop, offer to give them a lift, and explain that he'd won the lottery or had a big casino win, and that he was celebrating. In order to convince them, I think he had a plastic bag stuffed full of £10 notes and the like. Anyway, many of these women accepted the drink of champagne. Unfortunately, the champagne had been laced with sedatives, and once the sedatives had taken effect, the assaults were committed. And there was an attempt by the victims of John Warboys to bring a claim effectively against Warboys insurers on the basis that the assaults were caused by or arose out of the use by him of his taxi. And it's a very helpful decision because it adds further layers, if you like, to the principles set out in Dunthorne and Bentley. And I've set some of them out on this slide and the following slide. So arising out of is a wider concept than caused by. You have to consider whether the injuries of the claimant were matters arising out of the use of the car as opposed to something else. Arising out of excludes use being casually concomitant, not causally connected with the act in question. I think the judge was keen on his alliterations. Over the page, it's necessary to analyse the activities of the driver whose insurers are being sued to see what he was doing at the time when the injuries were suffered in order to ascertain if they were arising out of the use of the car. And continuing, the injuries of the claimant were caused by the criminal acts of Warboys in administering sedatives and then in attempting or actually assaulting the claimants. They did not arise out of the use of the taxi on the road. So that was the conclusion. The claims failed. And the judge held that there was, in essence, no link between the use of the taxi at the time and the sustaining of the injuries, the assaults, and the claims failed. But I have to say, I think that decision is surprising. Not surprising in terms of the principles set out in the case, simply the upshot, the judgment is surprising. The finding that there was no link between the injuries and the use of the taxi seems, with respect to the judge, to fly in the face of the facts. The assaults took place inside the taxi. It's difficult to see why the taxi wasn't being used in part to perpetrate those assaults. The ladies who were assaulted, the women who were assaulted, were picked up by using the taxi. And if you like, if you take the taxi away, John Warboys' MO for his assault just wouldn't have been possible. And so, look, it's a case, again, very helpful to those defending these sorts of claims. But it's a case which I think it can fairly be argued is a very surprising decision on the facts. So that's Warboys. We then move on to the case of Wastel and Woodward. It's a decision of Master Davison, and claimant lawyers amongst you may be relieved to learn that this one goes in favour of claimants. It's a case involving a chap called Gordon Johnny Woodward, who I think was a bit of a character. He owned a hamburger van that he used to park on a verge. He hadn't told his insurers that he used the vehicle as a burger van, not that was relevant for the case. And so one morning he parked his van and got out and carried a small sandwich board, a sort of advertising board, across to place it on the opposite verge. Having done that, he then went to walk back across the road to return to his hamburger van and negligently walked into Mr. Wastel, who was driving a motorcycle, and Mr. Wastel was badly injured. And the claimant's lawyers sought to argue that the act of Mr. Woodward in walking across the road was much like in Dunthorne and Bentley, connected to the use of his vehicle. And so they brought a claim. And the claim succeeded. And Master Davidson held, as you'll see from the slide, applying Dunthorne that the injuries were temporarily, geographically, and qualitatively. Temporarily, geographically, and qualitatively, the accident was closely linked to the use of the vehicle. And there was some debate as to whether the vehicle needed to be used as a motor vehicle, because this one wasn't being used as a motor vehicle, it was being used as a hamburger van at the time. He held that that wasn't a prerequisite to liability. And as I say, the case succeeded. He points out in his judgment that there's some tension between the decision in Dunthorne and the decision in Slater. He clearly took the view that perhaps Mr. Slater should have been successful because Mr. Slater was walking across the road in order to continue his journey with the taxi driver, just as Mrs. Bentley was crossing the road in order to gain assistance to continue her journey. But one case succeeded and the other failed. Anyway, Mr. Wastel succeeded on those facts. One point of note, however, is that on that issue of whether the vehicle needs to be used as a motor vehicle, I think 10 months after the decision in Wastel was a decision of the ECJ in the Rodriguez case I've set out on the slide there. It was a case involving a tractor being used as a pump, which toppled over and crushed somebody. And the ECJ held that that wasn't caught by the road traffic directive, because the tractor has to be used as a vehicle, and it wasn't being used as a vehicle. So perhaps Wastel might have been decided differently had that decision been available at the time. So the next case is the case of Pilning. I'm just going to deal with this very briefly. The reason it's included is simply because it's a Supreme Court decision, and it upholds or confirms the decision in Dunthorne. And there was some useful commentary, and you'll see there, Mr. Dunthorne's claim was close to the line, as Lord Justice Hutchinson recognised. But it was not apparent to me that the outcome of that borderline case was wrong, having regard to the close connection in time, place, and circumstance, those words mirroring, if you like, the phraseology of used by Master Davidson in Wastel. Close connection in time, place, and circumstance between the use of the car on the road and the accident. So, our final case, Carroll and Taylor. It's quite a sad case, really. The claimant was enjoying a night out in Liverpool. He had had quite a lot to drink. He decided that he needed to get a taxi home. And sure enough, he got a taxi, but unfortunately, the taxi driver was dishonest and somehow managed to take the claimant's debit card after the claimant revealed his PIN for that card. And having done so, he managed to get the claimant out of the vehicle and drove off. So the claimant found himself somewhat inebriated in the middle of Liverpool late at night, decided he was going to walk home. In the course of walking home, he unfortunately fell over a motorway barrier that was on a bridge, falling into the car park below, sustaining catastrophic injury. He tried to argue that his injuries were caused by or arose out of the use of the taxi, and unfortunately his claim failed. The essence of the finding really was that at the time he sustained his injuries, he was simply too far removed from the taxi. I think some 40 minutes had gone past. By the time he fell, I think it was established that the taxi was some 3 miles away. And so the court made the point that there has to be a relatively close connection in time and place. And the facts of this particular case were simply the wrong side of the line. It reiterated it's necessary to analyse the activities of the driver whose insurers are being sued to see what he was doing at the time when the injuries were suffered in order to ascertain if they were arising out of the use of the car. So an unsuccessful case. Further comment, Dunthorne was a borderline case. This, of course, means that although each case will turn on its own facts, the facts in Dunthorne and Bentley are likely to be instructive as to which side of the line other cases, including this one, will fall. And as I say, they found that the claimant in that case was unfortunately on the wrong side of the line. So those are the cases which I think you will agree largely repeat the principles, or finesse them, I suppose, slightly in the War Boys case. And the question arises, where do they leave us in the case of a road rage assault? Well, I think it's helpful to consider the sort of scenarios that might arise in a road rage assault to see if we can find safe ground or otherwise. And so on this slide, you'll see I set out a scenario. Mr. Angry, he's stuck behind a cyclist in a narrow lane, gets frustrated because he can't get past, finally manages to pass, and some verbal abuse is exchanged between the motorist and the cyclist as the overtake happens. And then 100 meters later, Mr. Angry stops his car and, first scenario, opens his car door into the claimant's path and injures him. Next scenario, gets out of his car, closes the door and pushes the claimant off his bike. And then third scenario, sees the claimant in the pub an hour later and punches him. So 3 scenarios, if you like. I think what the cases show is that scenario 1A is always going to be an easy victory for the claimant. If there's any contact between the vehicle and the injured party, it's going to be almost unarguable that the accident did not arise out of the use of the vehicle. So those are, if you like, the easy cases. The scenario 2 is also easy, but easy because it's likely to be unsuccessful. If the assault happens in a pub an hour later, it is removed in time, it's removed in location. There is no longer, or it can't be said to be such a strong link between the use of the vehicle and the injury sustained. So safe ground, if you like, but safe for the defendant. Those claims are likely to be lost. The difficult middle ground is scenario 1B, where, as I've said there, an assault happens, but there's no contact between the injured party and the motorist. And so you have, if you like, 2 different scenarios. You'll have scenarios where there's close proximity in time and place, and you can show, because of that proximity, it'll be easier to show that because of that proximity, the assault is motivated by, or you might argue, caused by the driving, by the use of the vehicle. On the other side, you've got, perhaps in the same setting, an argument where these sorts of assaults on the basis of the Canadian cases are the wrong side of the line. They're held to be merely incidental. This is what will be argued in defence of cases. And you will also have an argument based on the War Boys decision that a criminal act, particularly if it's premeditated, so the sexual assaults in War Boys or the shooting in Dickinson, you might be able to show, if you're defending the case, that there is no nexus between the driving and the injuries that were sustained. So, yeah, I mean, I haven't provided a clear answer for you if you have a case of this type not involving vehicular impact. But what I'm going to suggest is there are things that perhaps you need to look for in cases of this type. The first point on this slide is the easy and obvious one. Was there impact with the car? If yes, well, you're likely to succeed. The second point is you need to look for a connection between the driving and the assault. So as I put there in the bullet point, is it a classic road rage case, or is it some sort of premeditated act? If it's premeditated, the prospects will reduce. And again, using the test in Westell, was the assault temporally, geographically, and qualitatively closely linked to the use of the vehicle? And in getting to the bottom of those things, it was my experience in the case that I told you about that often the assailants are arrested in these cases. They will, certainly it's true in my case, try to explain their actions by saying that it was the driving that drove them to commit the assault, or something that the other driver did or said or something like that whilst they were driving their vehicle. And that can be helpful if you're obviously trying to link the driving with the assault. Likewise, sentencing remarks. Judges in sentencing hearings can say helpful or unhelpful things about the connection between the driving and the assault. And in the case that I had, for example, there were unhelpful sentencing remarks because although this isn't evidence, if you like, it's something that one can use to build an argument, or at least something that can be put to the relevant witnesses. The sentencing remarks included a line along the lines of that the assault wasn't about the driving, it was about the assailant's inability to manage his temper. And so you'll find that arguments, factual arguments, arise as to whether the cause of the injuries is really anything to do with the car as opposed to the individual characteristics of the assailant. And the final point on that slide, witness accounts of demeanour, whether someone is, it was witnessed being particularly angry, or there was something else that was seen that perhaps more closely linked use in some way of the vehicle with the assault that took place. But these cases in the middle ground will remain very difficult. They're classic examples of cases that would have a settlement value. That's what happened in my case. My client elected to take a commercial view in terms of settling his case. And I wasn't, I think, surprised by the insurers in the case that I dealt with adopting a commercial view and settling the case, because I suppose on one end of the seesaw, a claimant will be worried about losing a case of this type. But on the other end of the seesaw, it probably wouldn't suit most insurers to have a precedent set where a classic road rage assault wins out. They probably prefer to hang on to the Canadian cases and argue each case or approach each case commercially. And that perhaps explains why there isn't a reported case, as I said at the beginning, on Westlaw. So that concludes my presentation on this topic, but I leave you finally, just in case you found this to be a bit too legally dry, with the case of Emo and Gecko General Insurance. If you want to entertain yourselves in a quiet moment, I strongly recommend Googling that case and looking it up. Everyone in the case was unfortunate. The insurer suffered a £5.2 million default judgment in a case which involved a claimant who'd had a night of passion in the rear of a Hyundai Genesis motor vehicle. But she then learned several weeks later that she had caught a sexually transmitted disease in the course of doing that, and brought her claim on the basis that her injuries arose out of the use of the car. So a totally different jurisdiction, different laws, but quite an entertaining read that I'd recommend to you if you have a spare moment. So the presentation is now at an end. As I said to you at the beginning, if you have any questions, please feel free to email me. My email address is on the notes. That leaves me just to thank you all for attending, and hope you found this seminar of interest. Thank you very much.